Hello, and welcome to JD Advising's California Bar Exam Essay Guide. The goal of this guide is to help you find an effective and efficient approach to the California Bar Exam essays right from the very beginning. This guide will help you feel confident on test day so that you can conquer the essay portion of the California Bar Exam. If you have any questions about this or other resources we offer for the California Bar Exam, please don't hesitate to contact us. Some of our other resources include a California Bar Exam prep course, private tutoring, essay feedback, and one-sheets. If you reach out to us, we'd be happy to speak with you about the resources that can best help you prepare for the California Bar Exam. We hope you enjoy this guide and good luck on the exam. The final subject in the California Bar Exam Essay Guide is wills and succession. This subject is frequently tested on the essay portion of the California Bar Exam, so we're going to go over some tips for how to succeed on this subject. First, know how wills is tested. The California Bar examiners almost always instruct examinees to apply California law to a wills question. So as you're studying this subject, make sure you pay attention to California's version of the relevant rules. Also, wills is sometimes tested on its own and sometimes tested as a crossover subject. When it is tested as a crossover subject, it is most often crossed over with trusts and/or community property. Next, you should be aware of the highly tested wills issues. Some of the issues that we frequently see tested on wills essays include intestate succession, or in other words, what happens to a person's property if the person dies without a will, execution of a valid will, and the pretermitted child doctrine. Let's start with intestate succession. If a person dies without a will, the law dictates how that person's property should be divided. There are a lot of nuances here, but you should memorize them as the examiners do expect a lot of detail in your answer when this issue is tested. To determine who takes the decedent's property, first look at who survives the decedent. If there is no surviving spouse, but the decedent had children who survived him, then those children will receive equal parts of the decedent's estate. If the children are all of the same generation, we call this per capita. And if the children are of different generations, so for instance, some children and some grandchildren of the decedent, the distribution scheme is called per capita with representation. If there's a surviving spouse and children, the surviving spouse will receive 1/2 of the community property and quasi-community property. And according to California's community property rules, the surviving spouse already has the other half. So the surviving spouse essentially gets all of the community and quasi-community property. Additionally, that spouse will receive 1/3 of the decedent's separate property if there is more than one lineal descendant. These two scenarios, children but no surviving spouse, and children and surviving spouse, are the most commonly tested scenarios on the exam. Another frequently tested issue is the requirements of a valid will. In California, a valid formal will must be in writing, signed by the testator in the joint presence of two witnesses who understand that the instrument they're witnessing is the testator's will. Also, the testator must be at least 18 years old and must intend that the document is his will. A common problem we see in this scenario on the exam is that at least one of the witnesses is interested, meaning that the witness will receive some gift according to the terms of the will. California says that a will is still valid if it's signed by an interested witness. However, unless there are two disinterested witnesses, there's a presumption of duress, menace, fraud, or undue influence. Thus, the interested witness has to overcome this presumption, and if he can't, he cannot receive more than he would have received by the rules of intestate succession. So let's say, for example, a testator leaves everything to her son. Her only other heir is her daughter, but she's chosen not to leave her daughter anything in the will. The son is one of the witnesses to the testator's will. So this creates a presumption of duress, menace, fraud, or undue influence. If the son cannot overcome this presumption, he can't receive more than 1/2 of the testator's estate. The rules of intestacy likely dictate that the daughter will receive the other half. Another common issue in this subject is what happens if the testator writes a will, but there are no witnesses. California recognizes what we call holographic wills. A holographic will is valid if it is signed by the testator and material portions are in the testator's handwriting. So a will that is typed and signed by the testator likely would not be considered a valid holographic will. You might also see a fact pattern that involves a codicil, which is a supplement to the will that modifies, adds to, explains, or revokes the will. A codicil only changes the will to the extent that the codicil differs from the will. The codicil must be executed in the same manner as the will. So a valid attested codicil would have to be signed by 2 disinterested witnesses, or a valid holographic codicil would have to be in the testator's handwriting and signed by the testator. The final issue that I want to mention here is the pretermitted or omitted child doctrine. This is an issue when a testator writes a will, usually before that person has a child. So the child is not named in the will. That child is entitled to receive his or her intestate share unless the child was intentionally omitted or substantially all of the testator's assets were given to the child's other parent, or all of the assets were given to the child outside of the will, so like a life insurance policy or a gift made during the testator's life. In California, this doctrine also applies to children who were born before the will was executed, but about whom the testator did not know. The next tip for wills essays is to be comprehensive in your answer. Be sure to state the general rule before you state an exception. For example, if you see the issue of whether a will is valid, but there are no witnesses to the will, start with the requirements of a valid attested will and discuss why the requirements are not met. Then move on to discuss whether the will might nonetheless be a valid holographic will or whether it might be valid under California's harmless error doctrine. Similarly, if you see a pretermitted child, first define pretermitted child, then state the rule that the child is generally entitled to whatever share of the testator's estate the child would have received had the testator died intestate. Then state those 3 exceptions to the pretermitted child doctrine, such as if the assets are given to the other parent or if the child was provided for outside of the will. The 4th tip for wills is to be aware of some of the key wills vocabulary. Let's talk about some of the words you might see in wills that you may not be familiar with. Ademption is the failure of a gift. So for example, if my grandma leaves me her car in her will, but at the time of her death she does not own a car, then that gift adeems. Next is codicil. I mentioned this earlier. This is a supplement to the will that modifies, explains, adds to, or revokes the will. A descendant or issue is anyone who descends from the decedent, such as children or grandchildren. A devise or a legacy is just a fancy word for a gift given in a will. To disclaim is to reject a gift. Heirs are anyone who inherits property when the testator dies intestate. So this could include descendants, such as children and grandchildren. It can also include parents, siblings, aunts, uncles, etc. Intestate means to die without a will. So the laws of intestacy dictate how that person's estate are distributed. To predecease is to die before someone. Testate means to die with a will. And the testator is the person who dies with a will. You would simply call them a decedent if they die without a will. The final tip here is to practice. Practice is going to help acquaint you with the vocabulary, the highly tested issues, and also how to approach certain topics in wills essays. You should review the February 2019, February 2018, February 2017, and February 2015 wills essays.